Hello everyone, and welcome to the launch of Volume 48, Issue 4 of the University of New South Wales Law Journal. On behalf of the journal, I would like to begin by acknowledging the traditional custodians of the unceded lands in which we gather here tonight, the Bidjigal people of the Durag Nation. I pay my respects to their elders past, present, and emerging, and extend that respect to any First Nations peoples present. My name is Ophelia Zhao, and I am the Executive Editor of the University of New South Wales Law Journal. And it is my privilege to commence tonight's official proceedings for the launch of Volume 48, Issue 4, a thematic issue containing 9 articles and a book review on the topic Artificial Intelligence and the Law. In an age defined by data ubiquity and unprecedented technological advancement, the relevance of AI is both undeniable and urgent. Issue 48.4 exemplifies what the journal strives to do best: engage with timely, significant legal questions that shape and affect our broader community. Tonight would not be possible without the outstanding authors whose scholarship fills the pages of this issue, several of whom who are here tonight. Thank you for trusting the journal with your scholarship. And thank you for contributing towards rigorous, thoughtful debate on such contemporary and important matters. In responding to this timely theme, we are thrilled to be joined by the Honourable Chief Justice Andrew Bell, who will deliver this evening's keynote address. We are deeply grateful for your time and insights. Applause is also due to our remarkable student editorial body. Balancing the demands of study with the meticulous standards of the journal is no small feat. Tonight's launch is a testament to each editor's diligence, precision, and unwavering commitment. I would also like to acknowledge the Executive Committee. As the year draws to a close, and with it the tenure of some of us, I want to express how much I will miss working alongside such passionate, capable, and kind colleagues. It has been an absolute privilege to serve as your executive editor this year. And of course, this issue could not have come together without its dedicated issue editor, Bisesh Belbase. The role is well known for its demanding timelines and occasional late nights, yet every time I have seen Bisesh, he has been calm, good-humoured, and endlessly generous with his time. We are sad to see Bisesh go, but we also welcome Victoria Hong into the role. My thanks go to the UNSW Faculty of Law and Justice, and in particular, our 2 SAGE faculty advisors, Professors Rosalind Dixon and Gary Edmond, who are quick to remedy any pickle, and Professor Andrew Lynch, Dean of UNSW Law and Justice, who continues to champion the journal's work. Lastly, I would like to thank and recognise the extraordinarily generous contributions of the journal's premier sponsors, Cause Chambers Westgarth, Allens, Herbert Smith Freehills Kramer, and most importantly tonight, King and Wood Mallisons. This launch, and indeed the journal's ongoing ability to operate as one of Australia's leading academic law reviews, would not be possible without your continued partnership, and for that we are eternally grateful. Thank you all for joining us in celebrating the launch of issue 48.4. It is now my pleasure to invite Maura Seville, partner at King and Wood Mallisons, to speak on behalf of the firm.
Thank you. Thank you, everyone. My name is Moira Saville. I'm a partner at KWM in Sydney. I'd also like to begin by acknowledging the Gadigal people of the Eora Nation, who are the traditional owners of the land on which we meet today, and I pay my respects to their elders past and present, and I also pay my respects to all First Australians here today. Welcome everybody on behalf of King and Wood Mallisons, and I also welcome the Honourable Andrew Bell, the Chief Justice of New South Wales, who will be delivering the keynote address. KWM is privileged to have a long-standing relationship with the UNSW Law Journal. I am told that it actually predates my relationship with KWM. It's 40 years since We first began sponsoring the journal since 1981 as Stephen Jakes, and Stephen, that probably also predates the Chief Justice's relationship with KWM. I'll speak very briefly about the issue itself, which is obviously, as you know, artificial intelligence in the law. It's, as you know, a thematic issue. You've already looked. It's got 9 articles, which each analyse a different aspect of artificial intelligence and its implications for law and legal institutions. It's a very timely publication. The collection ranges from exploring how generative artificial intelligence is changing legal practice and what this means for legal education, which is a very current topic, to whether the current public sector frameworks, such as the New South Wales AI Assessment Framework and the EU AI legislation, are adequate for purpose or fit for purpose in relation to automated systems. It considers the misuse of Gen AI in litigation and practical responses, the limits of risk assessment tools in relation to the law's guidance function, and the promises and problems of using Gen AI in small value consumer claims. Other articles address queer responsive regulation for AI in healthcare, how to allocate copyright responsibility across the text-to-image pipeline, propose unfair competition principles as a solution to the copyright gaps for Gen AI inputs and outputs, and a topic that is dear to my heart, how systemic unconscionability can apply to wrongs in algorithmic contracting. So a lot there to digest. I'd like to congratulate the editorial board of the journal, and in particular Bisesh Belbase, who is the editor of this issue, and I now invite him to speak. Thank you.
Thank you, Moira, for the introduction, and thank you all for being in attendance tonight for this launch. As you heard, my name is Bisesh, and I'm the issue editor for the issue in your hands tonight. My role here is basically to give you a little peek behind the curtain as to how the thematic artificial intelligence and the law came to be. But I'll shelve that question for the time being, and I'll begin with a slight derail of how I put the speech together. So a hidden secret among issue editors is that some of us go into the Law Journal's YouTube channel and see what past editors had to say when we were put in the same position, and maybe just nab an idea or two. When I went and did the same, I also noticed something quite funny. Since the launch of ChatGPT back in November 2022, no matter the topic or the theme, almost every launch has had at least one speaker make a quip about AI and its externalities. So I'll return to some of those comments later, but for now, I'll use it to replace the question, why artificial intelligence and the law, with another? Could it be anything else? I mean, last fortnight, President Trump signed an executive order calling for, in his words, a Manhattan Project for AI. Last week, DeepSeek released version 3.2, which is allegedly 30 times cheaper than leading American models, yet beats them in some benchmarks. Even as I speak, OpenAI is reportedly preparing for the release of GPT 5.2 this week, which is meant to put them back in the lead. And some of these people genuinely think they are on pace to build machine God. And I'm not sure if we should just see that as an empty threat. So last month, Sam Altman tweeted that if all goes well, OpenAI will have developed, and I quote, a true automated AI researcher by March of 2028. And OpenAI made clear in their blog a few days ago that this researcher, let's call it GPT-8, is meant to build AI models better and faster than humans, which will expedite the process for, say, GPT-9, and then GPT-9 will help build the even better GPT-10, and so on and so forth. In their words, we're seeing a recursive self-improvement until superintelligence. That being said, taking a step back, I can definitely see the side, which feels like all this talk about superintelligence is sci-fi gobbledygook, which distracts from the real issues that are affecting us right now, such as the pervasive biases in AI models. And all this delirious excitement around AI does walk and talk like a bubble waiting to pop. Matter of fact, the same Altman who's been raving about Dyson spheres and superintelligences has been on record saying he sees a bubble forming around the industry. So take that as you will. I discuss with some classic undergrad hubris how regardless of which side is right. We're probably facing the barrel of a gun in my editorial. So I won't tread too much of the same ground here. Instead, what I'll talk about is the trust that I think most of us would agree is lost from the AI models that exist right now. I'll be talking about the concept of trust in quite mystifying terms, but I think trust is fundamentally quite a mundane thing. I mean, when I took the light rail here, I trusted that the multi-ton vehicle with thousands of moving parts wouldn't suddenly combust in itself. Or when I took a canapé earlier this evening, I trusted that it wasn't poisoned. Even as I stand on this ground, however many stories high, I trust that the building won't suddenly collapse in itself one 9th of December. Of course, we have the thrust of the law to step in if any of the relevant actors don't act in the way we expect them to. But what's amazing to me is that the Australian legal system is just a normative system. There's no law of physics that prevents us from going on green and stopping on, there's no law of physics that makes us go on green or stop on red. We just do it and trust that people will do the same. So there's kind of a feedback loop. We trust, at least in part, because we have the security of the law, but the legal system is maintained and propagated because we trust. It's a marvel of social engineering, but I think it's brittle enough for the stochastic parrots that we call AI to come in and erode that trust. I mean, to give a trivial example, as some of you probably suspected, every word I've said up until this point hasn't actually been the thoughts of my own. These are ideas generated for me by GPT 5.1 last night. I mean, they're not, but it's amazing how I don't really have a strong way of proving otherwise. And it's not just words either. A few weeks ago, music streaming platform Deezer released survey results alleging that 97% of participants could not reliably tell the difference between AI-generated music and human-made music. If you played around with any recent image-generating models, you know that they produce artworks that are sometimes depressingly nigh indistinguishable from the works of skilled artists. What progress is most scary to me, though, is the progress of AI-generated videos and how much more noise they'll add to truth-seeking. And if you buy into the superintelligence stuff, companies are currently investing in this underlying architecture of AI videos on the hopes of eventually being able to generate infinite synthetic data to train the models on. All of this progress has lots of interesting implications for all types of law, but I wouldn't dare try and tease out the exact implications of any field, especially when there's so many experts here in the room with us. Instead, what I'll do is end on a more personal and hopefully a bit more optimistic note. So on a macro level, I do think things are probably quite bleak and uncertain, but I'd be lying if I didn't say that in my narrow, privileged, sheltered view, I can't help but be a little bit excited. There no longer seems to be a safe and secure left for law students. We're stuck in the deep end of the waters, but no one quite knows how deep or shallow it really is because we're all on the same boat. On that, I want to return to the comments I flagged earlier. At the launch before this, partner at HSFK, Tamana Islam, noted analysis, which counterintuitively sees partners at big law as being the ones most at threat of being replaced. At the launch of issue 46.2, Justice Beach Jones said, and I quote, "When our university's quantum computers are hooked up to an AI engine, we are all doomed." So I can describe modern life with a lot of things, but I probably can't describe it as boring. All that said, even if November 2022 marked a turning point where we started to hand the keys of control to AI, I think we'll see a few individuals stand out in the training data for their incisive commentary and judgments during this uncertain period. I think we're in the presence of one such judge tonight. For the prestige inclined, his honour has had enough accomplishments to fill several distinguished careers. To name just a few, we have USyd medalist, Rhodes Scholar, President of the Court of Appeal, Lieutenant Governor of New South Wales, Chief Justice of New South Wales, and tonight we have the privilege of hearing his honour as a keynote speaker for 48.4. Please join me in welcoming Chief Justice Andrew Bell.
Well, thanks very much, Bashesh, and good afternoon, everyone. It's almost the end of the year. I know the students have finished your exams, I think. probably all looking forward to a holiday. I'm looking forward to a holiday from AI because it seems to have, in competition with PLT, AI has dominated my year, at least beyond my core responsibilities. So thank you very much for your attendance, and to the editor, general editor, and the editor special issue, inviting me to write the foreword and give a launch speech. I wanted to, at the outset, say something about this law school. I've made it part of my role as Chief Justice to have a more deliberate line of communications with the law schools in New South Wales than perhaps has been so previously. There's been interaction, obviously, between the court, but I've certainly taken the view that we should make it more deliberate, more extensive, etc. And so as a consequence, not just with this law school, but certainly to a large degree with this law school, I've had a lot of contact over what is coming up for 4 years for me as Chief Justice, and particularly over the last year. And I just wanted to say I think this is an outstanding institution. The UNSW Law School's got outstanding leaders from the Dean down. I think the Centre for the Future of the Legal Profession is a very dynamic organisation. The papers it's produced, the two most recent papers which I've read, I think are terrific, and I think the engagement is engagement with the court. We have a number of specialist seminars through the year, public law and private law, where there are UNSW academics come to the Supreme Court and meet with the judges, senior judges, to just discuss topics of interest. And then there's also lines of communication about things like practical legal training, etc., in which, at least as Justice Tony Payne and I conceive it, should sort of start at law school and continue through a bespoke course and then continue post-admission, but some of you are aware of that. And we're certainly benefiting from the interaction. So I wanted to make those remarks from the outset. Well, congratulations to the editors. I've read everything in this journal. Actually, I don't always read every page of books I'm asked to review, or just let you in on a little secret. But I did actually read everything in this one, partly as part of my ongoing education in AI. The big challenge, I think, for me and people in equivalent positions who are in a particular area, not just the law, but particular areas, is constantly to think about how AI is impacting our particular areas and how we respond. And everything, as you know, is moving so quickly, and it's very complex, that I took the view probably towards the beginning of last year that I just had to educate myself very fully about AI and developments, because you can't hope to regulate something, or at least express a view about regulating something, unless you know about it and are thinking about it deeply. So AI, as I've said, has loomed large in my world, and I've written, given a number of speeches about its impact on the legal profession. I think it's very important not to generalise about AI's impact. I mean, one can make some general statements about the rapidity of its development, the pervasiveness of its impact, and that's true, but thinking about it in particular contexts in the law, or at least for the courts, which are concerned with ascertaining truth, ensuring the integrity of evidence so that the law can be applied faithfully to the facts as faithfully ascertained. There are particular issues of authenticity, integrity, reliability, etc. And so we have developed our guidelines in New South Wales, which some of you may know about. They're said to be certainly at the conservative end of the spectrum, if not the most conservative end of the spectrum around developed nations around the world, but I don't make any apology for that, actually. I mean, I think in terms of using AI to produce evidence, factual evidence, I think it's very, very concerning. I'm very concerned about the use of deep fakes for documentary evidence, for video evidence, for audio evidence, etc. And so we have to, I've taken the view we have to be conservative, but certainly law firms are embracing it, or at least aspects of it, and I know there are a lot of law firms who are working hard to develop the responsible use of AI. But whether they're law firms who are doing that, or government regulators, or the courts regulating, we all have to know about and understand at a sophisticated level the potentiality, the potential risks, the upsides, etc. And that's why this journal is so timely and so important. Bashesh touched on issues of trust and truth-seeking. They're quite big questions. They're sort of large questions with which we have to grapple. On the one hand, there's this great excitement. There's the rush to have the latest technology. There is this sort of powerful combination of the commercial incentive for the developers of AI platforms. Of course, there's an arms race happening. Different developers trying to get companies and organisations and governments to sign up to their versions of AI, and there's a lot of spruiking, old-fashioned spruiking. It's a shiny new product, and so there are claims being made about the quality, the reliability, the efficacy, the integrity, etc. So there's that combination. There's also the fact that AI is a persuasive medium. It presents outputs in a persuasive way. You ask AI a question, it gives you an apparently attractive, highly articulate, plausible answer. So one's first impression is to be impressed. Wow, this is powerful, this is good, this is coherent, etc. And yet we know in the law, we see particularly, but presumably it happens in other areas, the problem of hallucinations, which has not been a problem to my observation that actually has been solved or is anywhere near being solved. It continues to be a major problem. And another major problem continues to be that, notwithstanding attempts to regulate professionals such as lawyers, etc., lawyers are using it in the face of practice notes, etc., and it is causing real issues for courts. So one of the areas where AI is said to be very powerful, powerfully beneficial, is improving access to courts, but it's unrepresented litigants who, and I'm not critical, people who are unrepresented are often unrepresented because they don't have the means to afford a lawyer, and so it's not surprising that we'll resort to open model or large language, open system AI platforms, but it's there that we're particularly seeing judges, particularly at lower court levels and tribunals where there are more unrepresented litigants, having to deal with submissions, evidence, etc., which has been produced by AI and produces something which is unreliable, on its face unreliable. And when you see you get a document, any judge getting a document which is unreliable immediately makes you wonder about the reliability of other material, etc., and that can create a very time-consuming and added demand on busy tribunal members and judges at different levels. Anyhow, it is, as Bishesh just said, this brave new world. He talked about, I took it down, the deep end, the law students say at the deep end of the waters. There's a well-known Supreme Court judge called Justice Hammerschlag, who's the judge of the commercial. Oh, he's a chief judge in equity, but he ran the commercial list for many years, and I used to appear in front of him. Whenever I was in trouble in a case, he would say in his heavy South African accent, he said, "Dr. Bell, you seem to be at the deep end of the pool without a snorkel." Well, it is a bit, dealing with AI is a bit like that. We've just got to keep focused and keep adjusting and educating ourselves, etc. So it's not going to go away. People are embracing it. People are working out how to use it responsibly and reliably, and the profession is adapting to it. Even in the month or so since I wrote the foreword to this edition of the journal, there have been very significant developments, both in the use and capacity of AI technologies and also in regulation. We've seen only in the last week the federal government has issued its stance on AI regulation, and that's one of the topics which is discussed in a number of the contributions in the journal, a contrast between the model in the EU, which is a fairly heavy mode of regulation, contrast to the US, for example, and other jurisdictions where there's far less heavy regulation, and the recently announced model in Australia is probably mid-level, but on the fairly light regulation, light end, which one might think is controversial. On the other hand, we've also seen the social media ban being introduced, and that's partly been introduced in response to the ability to use AI technology to generate deep fakes, particularly pernicious deep fakes, false material or material which creates images of people, fabricated images, but very plausible, very realistic images, often using people's identity, images of people, and then changing the context, changing the background, etc., which is a major social problem in schools. We know that, a problem which is feeding into not just bullying, but sexual harassment and the like. And as I've said, that very same technology poses a risk for the courts in dealing with reliable evidence. One of the things is this, I've said this in a number of speeches, there have always been forgers. So, the law students would know about cases of forgery and what you do in those circumstances. You look at it in criminal context, you look at it in contractual context, etc. But forgery is quite an art. In fact, some of the early convicts who came out as forgers became some of the most famous early colonial artists because they were so good at their craft, took real skill. But forgery, technological forgery, has now been democratised. You can get very cheap apps or free apps which allow you to fabricate documents, other images, etc. The skill is supplied by the technology. The use of the technology is relatively easy, doesn't take the skill of an old-fashioned forger. So we have this particular change. So the way AI is being regulated is a very interesting study in itself. It's an interesting point of study for legal academics who are interested in regulation and regulatory theory. It's a very important topic for politicians. Of course, one of the problems with a very rapidly moving technology is that regulation is often 2 or 3 or 4 steps behind, because it's a slow-moving process, there's consultation, there's bureaucracy involved, there's sometimes political debates involved, and so in one sense it's extraordinary that the federal government's only just released a policy, a broad policy on AI. We, in the Supreme Court, introduced our practice note a year ago. The federal courts are still to issue any practice note, any guidance. We've opened our practice note up for review, so we've invited people to put in submissions by, I think, maybe the end of next week, etc., so we can consider over January whether we need to tweak our policy or change our practice note or change it, etc. So that's one area. Another issue relating to timing is this. Cases are working through the courts internationally on the copyright questions, for example, on the privacy, data protection questions. There have been already some big settlements in the US, a big class action, where one product which offered the apparent security of closing your system so that the data you input into the platform for analysis by the AI model was kept private, but of course it didn't work, and so there was a massive class action which settled for $500 million. I think there'll be a huge amount of litigation in that area. So there'll be new challenges for lawyers, and the courts will have to adapt. As Moira said, how do doctrines of unconscionability operate in this space? There's also the question of who takes responsibility. I mean, there is this big question of who actually understands how this works. You read articles where it says some of the leading engineers don't actually understand, can't actually explain how particular models work. That's the black box conundrum. That's why, for example, we're very cautious in the Supreme Court about the use of AI by experts, because if you know your evidence, you know that an expert has to give his or her reasons, has to explain the reasoning leading to the expert opinion, and that's partly so that the judge can assess the logic of the explanation. It's also so the other side can test the ultimate conclusion by understanding the steps taken. If there's a flaw in the steps taken or the assumptions made, then that might affect the viability of the opinion. But this question of who is responsible is a large question, because when things go wrong with AI, which they will, it's not perfect. We know it has flaws, but it could cause a collapse of a trading system, for example. It could cause the collapse of a banking system or aspects of banking systems, and there'll be questions of loss and liability. So there will be significant litigation about who is responsible, and if it's been caused by the operation of AI platforms, who is going to take responsibility, bear ultimate responsibility for that. So that's also an issue which is touched on in this issue. I don't want to say too much more because I know you're all desperate to read the journal, and I don't want to ruin your opportunity to do so. I'm in University of New South Wales, all students, I can just imagine, down at Bondi with their volume 4 of the journal, just reinforcing their reputation for being the coolest kids in school. It will be a very good look, I'm sure. Anyhow, enough of that. I think there's probably still drinks and things to go. So congratulations to Bishesh and the editors, the general editor. I have an idea how much work goes into producing something like this. It's very good training. One quality which makes a good lawyer is attention to detail. Whether it's a solicitor or a barrister or a judge, you have to have extremely good attention to detail, and editing something like this with dense references, lots of technical information, fact-checking, verification, getting second opinions, etc., is actually very good training to be a lawyer. So from what I can see, the quality is extremely high, not just of the content for the authors, but also the quality of the production. So anyhow, thank you very much. I hope you all have a good summer break, and good luck with whatever each of you are going on to next year. Thank you.
Well, thank you very much, Chief Justice. So, for those of you who don't know or haven't met, my name's Andrew Lynch. I'm the Dean of the Faculty of Law and Justice. So thank you very much, everybody, for attending tonight. I play the traditional role, essentially, of issuing a few final votes of thanks all round. And I begin, of course, with the guest speaker who launches the journal. So I really want to thank Chief Justice Andrew Bell for his comments tonight and for travelling to UNSW on a very warm, hazy Sydney evening to launch Volume 48, Issue 4. The emergence of Issue 4 from the journal offices is a sign that the end of the year is nigh. It's a very reliable signal that Christmas and the New Year is around the corner. But it's always a big occasion, and Your Honour's attention to AI is very well known, and in the foreword I note that you say that you spend every single day thinking about it and have done for almost 4 years now. And I have had the privilege of hearing you speak about it several times now, and each time that I do, I think more deeply about the topic. I learn something new. Tonight I even had sympathy evoked for the lost artisanal art of forgery. I hadn't thought of that dimension previously, but the problems and the questions just keep mounting up. But also I always really admire the tone with which you kind of earth the discussion, which is often overhyped about the potential of AI, but also a little over doom laden as well, by asking quite practical questions which require lawyers and academics to turn their minds to these challenges and to find a way through. So I appreciate your comments tonight as extending that conversation. It's a series of ruminations, thoughts and provocations on AI, and we are all the better for hearing it. I also want to acknowledge, though, Your Honour's leadership on this topic, which, through the practice direction that you referred to, is well understood, not just in New South Wales or around Australia, but internationally. And any of us who have talked about this topic in international circles know that New South Wales is very much on the map in terms of thinking around AI and providing judicial leadership on this topic that is perhaps lacking in other jurisdictions and receives very favourable comment. Judge, you said that you are looking forward to having a holiday, I think, of any kind, but of talking about AI and also talking about PLT. And I wish you well for quite a long holiday talking on those topics. But I really wanted to acknowledge your compliments to the university tonight, and to really say that the engagement that you alluded to has been made possible by your own approach, and to thank you for the way in which you have engaged with the Academy across the state on these really critical issues of artificial intelligence and also practical legal training. And it struck me when you were speaking that you really are the friend of the young lawyer of New South Wales, for whom the issues of AI and what that will mean for careers in the profession are particularly pressing. but also the quality, relevance and affordability and therefore access of practical legal training. And UNSW launched our own offering in PLT in 2019 because we felt that there was change needed in that area and that we could offer something different. And we're very proud of the PLT program that we have offered in those years. But we are also very excited about the changes that hinted at in the LPAB's consultation paper and have been signalled both in your own remarks and those of others. And I think, addressing issues that have been long discussed as ones that need improvement is a really great example of actually biting that bullet and changing a state of affairs which will directly affect, I think, lots of people in this room and also future generations of lawyers for the better. So I really wanted to thank you and to recognise that leadership. Thank you for being here tonight. There's a few other thank yous, obviously, to give. I really want to thank Moira and I want to thank our friends at Kingwood Mallison for their sponsorship of the journal as well as the other sponsors. That a very long relationship in supporting the journal is deeply appreciated. It has made the journal what it is, which is a really astounding publication, which is, as I always remind everybody, entirely independent of the faculty. It is student-run. There is a touch point of the faculty, and I'll come to those two colleagues very shortly, but the faculty really just basks in the glory of our students' achievement and their dedication, but it is the sponsors who have made that support available to them which has led to this. So we really thank you, and thank you very much for joining us as well. I want to congratulate all the authors. Academic life is very demanding. Finding time to write on any topic, very challenging, but finding time to work on something that is so fast-moving, irritatingly fast-moving, I would have thought, is really contributing to a public debate of great importance, despite the fact that it will really be a much harder thing to research and write on, say, than other worthy works one might do in legal history or even, I might have said, constitutional law, though that's more active than it used to be. Well done to all authors, and for all of you who are here tonight, whether as colleagues of mine or as guests, it's really wonderful to see you. I do want to thank my two colleagues, Gary Edmond and Ros Dixon. I don't know if Ros is still here. She has left. Well, it was really fantastic to see her. Mimi, Zoe and I came in and I said, Ros, I've heard you've been ill. What are you doing here? And she said, I'm fine. I've been to hospital and it's all okay. And I can be here for about half an hour. And that's Ros's dedication, and you can't keep her down. So she's. It was great for her to be here. That she's a very passionate supporter of the journal, and I'm not surprised that she checked herself out of hospital, swung by here to say congratulations to all involved, and hopefully is now going to get some rest. But the advisors, both Gary and Ros, are very proud of their association, and I know provide assistance. Now I turn, I think it has to be said, to the real stars of the show, and that's of course everybody who has been involved in the editorial team of the journal. I am, as people know, a bit of a UNSW Law Journal tragic and aficionado, and I spotted two things which I had never seen before inside the journal, Basesh, so that's pretty amazing. One is the use of art inside the journal. I may be proven wrong. I mean, the journal's quite old now, but on page 1120, there is a whole page given over to a picture. Thought that was a bold innovation and very welcome. And I also wish I'd been involved in the meeting of the relevant editors who had to grapple with the footnote on page 1129, which involves how to reference REMs. It's the end of the world as we know it. I don't know that a musical song has previously been the subject of a footnote either. Doubtless Ophelia will correct me on both these scores and say there was artwork in issues, volume 17, issue 2, and of course everybody else would know that. But I hate to suggest that I'm glib or insufficiently intellectually engaged. There's a lot in the journal beside a picture and a footnote to an REM song, and I look forward to reading all of it, but those certainly have leapt out as early distinctive qualities, and each of the articles looks particularly fascinating. Obviously the one by Lachlan Robb, others, and Amanda Kennedy, who's a colleague I know well as Dean of Law at QUT, bringing together the Chief Justice's particular areas of great interest, which is to talk about AI and competency for lawyers, is a paper that I'll be paying very close attention to. I want to acknowledge the Executive Committee for their work and leadership. Of course, with one issue published, the Executive Committee grows and a new member arrives. We're looking forward to the 2026 volumes of the journal. And so I congratulate them as well as the editorial team. Obviously, Bisesh, congratulations, fantastic speech, and well done on issue 48.4, which, as I tend to say, this is your issue now. This will sit on a shelf in your house until your dotage, I'm sure, because you only ever do this once, I would hope. Congratulations. It was lovely to meet your family because, as we know, the journal isn't just a team effort of students, but also involves very tolerant and understanding friends and family who have seen you sacrifice a great amount of time to this. And so it's only fitting that we should be joined by your family here tonight. Thank you and congratulations. And I also really wanted to acknowledge Ophelia's contribution as the General Editor of 2025. This is a massive job. I don't think anyone does a sprint. I don't think an issue edit, it doesn't feel like a sprint, does it? It feels like a long run. But the General Editor is there for all 4 issues. They're there for the long haul, supporting and encouraging their issue editors, the whole editorial team, dealing with the faculty, that can be difficult, working with sponsors. And Ophelia's had a massive year, and it began in this room with a reunion of all editors that we could find over the 50 years of the journal, and that was a really remarkable night. And it was great. She came to me with this idea. I had not noticed that the journal was 50 because it's only up to volume 48, and she can explain to you why that is. But it was a really remarkable celebration, and this has been a truly golden year for the journal under Ophelia's leadership, and I want to acknowledge and thank her too, and wish all those who inherit this mantle the very greatest of success, and know that we are here to support but also respect your independence and autonomy. Thank you very much, everybody. Good night.
With Volume 48, Issue 4 of the UNSW Law Journal now officially launched, we have reached the conclusion of tonight's formal proceedings. Please feel free to stay and mingle for the next 20 minutes or so. If you have not yet collected your complimentary copy of the journal, please do so. And the full set of the articles will be available on the journal's website from tomorrow. Thank you again for your attendance, and I do hope you enjoy the rest of your evening.